All right, folks, let's have a serious talk. 10 brand new rulings from the Supreme Court have just completely redrawn the map for gun owners when it comes to police encounters. And believe me, rule number 1 is such a bombshell that police departments across the country are literally scrambling to rewrite their training manuals as we speak. If you're carrying a firearm and you don't know these new rules cold, your next traffic stop could go from routine to life-altering in a heartbeat. The legal ground has fundamentally shifted under our feet. What I'm about to break down for you isn't just legal theory. It could literally save your life and your freedom. Rule number 10, the Silent Shield Protocol. Now, listen up, because this first one is a legal superpower that most gun owners have no idea they possess. When you're in an encounter and you feel an officer is starting to step over the line, crossing into that gray area and violating your constitutional rights, there is one specific phrase that acts like a full stop. It is so powerful that the second the words leave your mouth, the entire dynamic of the situation legally changes in your favor. You need to commit this to memory, word for word. Officer, I am invoking my Fifth Amendment right to remain silent. I am invoking my Sixth Amendment right to an attorney, and I do not consent to any searches or seizures. What makes this the nuclear option is that once you have clearly invoked these rights, a legal wall goes up. Any evidence they gather after that point can be deemed inadmissible and thrown right out of court. Any confession they try to squeeze out of you becomes worthless, and any further escalation on the officer's part becomes a serious constitutional violation that the courts, under the new Martinez ruling, are now forced to scrutinize with a microscope. I have personally seen this exact phrase turn potential felony charges into dismissed cases and transform wrongful arrest situations into six-figure settlements. If an officer keeps pushing, keeps interrogating, or escalates after you've planted your flag on your constitutional rights, he's just proving to the court that his actions stopped being about legitimate police work and started being about ego, intimidation, and a blatant disregard for the law he swore to uphold. Rule number 9, the preemptive documentation strike. This next rule could be the one thing that keeps you from spending a fortune and years of your life fighting a bogus charge in court. It's so simple you can do it with a couple of taps on your phone, yet 99% of gun owners never even think about it until it's far too late. The absolute second you see flashing lights in your rearview mirror, or perceive that officers are approaching you for an interaction, you need to activate what I call the triple documentation protocol. 1. Start recording audio, or even better, video on your phone. 2. Verbally timestamp the encounter for the recording. 3. Verbally identify any witnesses who are close enough to see or hear what's happening. Here is the exact script that has saved countless responsible gun owners from a world of hurt. It is currently state the date and time. I am being contacted by police at state your location. I am a legally licensed firearm carrier, and I am currently armed. I am recording this interaction for the safety and accountability of all parties involved. This isn't just about catching a cop in a lie. It's about creating an immediate, unchangeable legal record, a record that proves your state of mind, establishes your level of cooperation, and demonstrates your constitutional awareness from the very first moments of the stop. Under these new Supreme Court standards, the courts can no longer just gloss over what happened in those first critical seconds. Your recording could be the single piece of evidence that separates you walking away free from spending your life savings trying to prove your innocence. Rule number 8. The constitutional carry shield now. For those of you living in a constitutional carry state, if you think that means you can just go about your day with a firearm on your hip without understanding this rule, you are setting yourself up for a dangerous and completely avoidable confrontation. Here's the critical distinction most people miss. Even in a free state, an officer can still temporarily detain you if he can articulate specific suspicious activity. What he cannot do is detain you simply because you are lawfully exercising your right to carry a firearm in plain sight. The phrase that has repeatedly stopped unlawful detentions dead in their tracks is this: "Officer, I am legally carrying this firearm under my state's constitutional carry laws." I do not pose a threat to you or anyone else, and I am happy to cooperate within my constitutional rights. That word, within, is the key. You are not being defiant. You are respectfully establishing the legal boundaries for the interaction. Now, a common tactic is for the officer to escalate, saying something like, "I need to secure that weapon for officer safety." But here's the part they don't say out loud. Thanks to the new Supreme Court precedent, they now have to justify that safety concern with specific, articulable facts, not just a vague, generalized feeling. Your calm, measured response should be, "Officer, I understand your concern for safety. However, I am currently exercising my constitutional right to carry. I need you to articulate the specific suspicious activity you have observed that would justify disarming a law-abiding citizen." This simple statement shifts the legal burden squarely back onto the officer's shoulders. It forces him to justify his actions with facts, rather than letting him hide behind that old, worn-out, officer safety excuse that courts use to rubber stamp without a second thought. Rule number 7. The vehicle fortress defense. Think of your vehicle as your castle on wheels. This rule will teach you how to turn it into a legal fortress, one that can shield you from the illegal searches and unlawful seizures that wreck lives and tear families apart every single day. When an officer approaches your vehicle during a traffic stop and you are lawfully armed, the first 30 seconds are everything. They determine whether this ends as a simple ticket or a life-altering legal nightmare. And frankly, most gun owners completely blow it in these first 30 seconds by talking too much, or by consenting to things they have zero legal obligation to allow. Here is the protocol that has proven time and again to protect gun owners from having their cars tossed and their firearms illegally confiscated. First, keep both of your hands clearly visible on the steering wheel at the 10 and 2 position. If it's dark, immediately turn on your interior dome light, and when the officer asks that inevitable question, "Do you have any weapons in the vehicle?" your response needs to be calm, clear, and precise. "Officer, for your safety and mine, I want to inform you that I am legally licensed to carry, and I am currently armed. My firearm is secured, it poses no threat to you, and I do not consent to any searches of my person or my vehicle." The power of this statement is in its efficiency. In one single sentence, you have disclosed your legal status as a gun owner. You have completely eliminated the element of surprise, and you have firmly established your constitutional boundaries. The new Martinez ruling specifically requires officers to have concrete, articulable reasons to conduct a search. The old excuse of, "I felt unsafe because he had a gun," no longer holds water when dealing with a citizen who is legally licensed and has conducted a proper professional disclosure. Rule number 6. The Home Sanctuary Protocol. Your home is your sanctuary. It's the one place on earth you should be safest. But if you don't know this rule by heart, police can turn that sanctuary into a crime scene before you can even say Fourth Amendment. And once they cross that threshold, every single thing you own, including your legally owned firearms, can become evidence used to build a case against you. When law enforcement shows up at your door, it doesn't matter if it's for a noise complaint, a so-called welfare check, or a claim that they're investigating a crime. You have absolute constitutional rights that most people accidentally throw away in the first 10 seconds. This is the script that has prevented countless unlawful home entries and protected gun owners from having their entire firearm collection illegally seized. Officers, I can see you at my door. I am exercising my Fourth Amendment rights, and I do not consent to you entering my home without a warrant. As is my right in my own home, I am legally armed. I am happy to speak with you through the closed door, or I can step outside to talk if you prefer. The critical, catastrophic mistake that people make is swinging the door wide open and taking a step back. Courts have repeatedly ruled that this simple, hospitable gesture constitutes implied consent for officers to enter. Instead, if you decide to open the door at all, you crack it just enough to speak through. Even better, step outside yourself and pull the door closed firmly behind you. Or, the safest option of all, simply speak to them through the closed and locked door. Never surrender your Fourth Amendment rights at the threshold of your own home. Rule number 5. The Miranda activation trigger. Most people believe that Miranda rights are something that only kicks in after you've been arrested and put in cuffs. That is a deadly misconception. It's a legal misunderstanding that has probably destroyed more lives than any other. If you wait until you're in the back of a squad car to invoke your rights, I guarantee you, it is already too late. You've likely already said something that can be twisted and used against you. The second, a police encounter shifts from a consensual conversation to a custodial interrogation. You must invoke your Miranda rights immediately, even if you have not been formally arrested. So, how do you recognize that critical shift? Here are the telltale signs. The officer's tone changes from inquisitive to accusatory. He stops taking your statement and starts asking probing questions about your whereabouts or your activities. He begins to restrict your movement, blocking your path, or making you feel like you are not free to leave. Or, he starts treating your legally possessed firearm as evidence of a crime, rather than as the exercise of a constitutional right. The moment you detect that shift, this is the phrase that has stopped countless gun owners from accidentally talking themselves right into a felony charge. Officer, I am going to exercise my right to remain silent, and I want to have an attorney present before I answer any of your questions. Now here is the most important part, the part most people get wrong. Once you have invoked Miranda, you must actually remain silent. Do not try to explain why you're invoking your rights. Do not try to convince the officer of your innocence. And for the love of God, do not agree to answer just one more question. Your silence is a constitutional shield. Use it. Rule number 4. The movement narration defense. This tactic has prevented more officer-involved shootings of legal gun owners than perhaps any other single technique. It is so powerful because it turns a potentially ambiguous, split-second decision into a clear, indisputable record of your innocence. But most gun owners, in the stress of the moment, never think to use it until it's too late. Every single movement you make during a police encounter, and I mean every gesture, every reach, every shift in your posture, must be verbally announced before you make it. You have to remember, police officers are trained to see any sudden, unexplained movement as a potential threat, especially when they know you are armed. This is the exact protocol that has saved lives. Officer, my wallet is in my back right pocket. I need to reach for it to get my license. Is that okay with you? Wait for a clear verbal acknowledgement. Okay, I am now slowly reaching for my wallet with my right hand. My left hand is staying here where you can see it. Move slowly, deliberately. No sudden jerks. I have my wallet now. I am now going to retrieve my license. This isn't about being polite. It's about creating a bulletproof record. A record that proves to any future judge or jury that your movements were announced, intentional, and completely non-threatening. With the new Martinez ruling, courts are now required to examine the entire chain of events. That includes whether you properly announced your movements and whether the officer gave you clear instructions to proceed. I have analyzed dozens of shootings where good, law-abiding gun owners died because they made a simple, unexplained movement that an officer misinterpreted as a threat. The ones who survived these encounters are almost always the ones who narrated their every action and waited for permission before they moved a muscle. Rule number 3. The Escalation Recognition System. This rule could save your life by teaching you how to read the warning signs. It will help you recognize the exact moment a routine police stop starts to shift into a dangerous one, giving you those precious seconds to de-escalate and adjust your behavior before things go critical. Most gun owners are completely oblivious to these red flags until the situation is already out of control. Police officers, especially ones who are poorly trained or have a bad attitude, tend to escalate encounters in a predictable pattern. Once you learn to spot these tells, you can see when an officer is about to cross the line from lawful policing into constitutional violations or excessive force. Here are the warning signs that signal immediate danger. The officer's voice changes from a professional, calm tone to an aggressive, demanding one. He stops making requests and starts barking orders. His body language becomes confrontational. He might blade his stance or place a hand on his weapon. He starts twisting your legal activities like recording the stop into suspicious behavior. And the biggest red flag of all, he starts ignoring your clearly stated constitutional rights. When you recognize these escalation signals, you must immediately shift into what I call defensive compliance mode. You become even slower and more deliberate with your movements. Your sentences become shorter and clearer. You increase your verbal documentation, noting his behavior for the record. And you mentally prepare to use your constitutional nuclear option if he pushes you too far. Here is the script that can de-escalate 90% of these tense situations. Officer, I can sense that this situation is becoming tense, and I want to ensure that we both remain safe. I am not resisting you. I am trying to comply with all of your lawful orders within my constitutional rights. That phrase, lawful orders, is critical. It respectfully reminds the officer that you know your rights, and you know the difference between a legal command and an illegal demand, and it creates a powerful record for any future court review. Rule number 2, the disclosure decision matrix. Pay close attention to this one. This rule will prevent you from making the single most dangerous mistake that gets legal gun owners shot, arrested, or charged with a crime they did not commit. It all comes down to knowing exactly when, how, and if you should disclose the fact that you are carrying a firearm during a police encounter. Most gun owners think this is a simple question. Your state law either says you have to or you don't. But the reality on the street is far more complex, and making the wrong choice can have deadly consequences. First, in duty to inform states, the law is clear. You are legally required to disclose. But the timing and method of that disclosure can be the difference between an officer treating you like a fellow law-abiding citizen or a deadly threat. Never, and I cannot stress this enough, never just blurt out the words, "I have a gun." Those 4 words send an officer's heart rate and adrenaline through the roof, and will almost always cause his hand to move toward his own weapon. Instead, you use this precise professional script. Officer, before we begin, I want to inform you that I have a license to carry a concealed weapon, and I am currently armed. My firearm is located on my right hip. My hands will remain on the steering wheel unless you direct me otherwise. Look at what you just accomplished with that statement. You established your legal status. You completely removed the surprise factor. You told him exactly where the weapon is, and you demonstrated through your actions that you are not a threat. But in states where you are not required to inform, the decision becomes tactical. If the officer is aggressive from the start, or if you believe there is any chance you might be patted down or searched, disclosing your firearm can actually be a protective measure. It shows cooperation and prevents the kind of sudden discovery that has led to so many tragic shootings. The key is to read the officer's demeanor, assess the nature of the stop, and analyze the overall risk level of the encounter before you make your disclosure decision. Rule number 1, the Officer Safety Destruction Protocol. All right, this is the big one. This is the rule that shatters everything you thought you knew about police encounters, because it completely demolishes the biggest lie that has been used to violate the constitutional rights of gun owners for more than 50 years. For generations, a police officer could justify almost any action. We're talking illegal searches, unlawful detentions, excessive force, even deadly shootings, by uttering 2 magic words: officer safety. Those 2 words were a constitutional get-out-of-jail-free card, a phrase that courts would accept almost without question, no matter how unreasonable or flagrantly excessive the officer's actions actually were. But the Supreme Court just took that card, ripped it into 1,000 pieces, and threw it in the fire. They did it in a landmark ruling so powerful, it is forcing a complete, top-to-bottom rewrite of police training across the entire nation. In the case of Martinez versus Thompson, the court was crystal clear. They stated explicitly that officer safety concerns must be specific, articulable, and objectively reasonable based on the totality of the circumstances. They can no longer be based on vague feelings, hunches, or a blanket fear of legally armed citizens. This means that when an officer wants to disarm you during a traffic stop, he can no longer just say, "I felt unsafe because he had a gun." He now has to explain to a court exactly what you did that created a specific safety risk. Was it your words, your body language, your actions? And most importantly, would a reasonable officer in that exact same situation have had the same specific safety concerns? Here is how you use this groundbreaking rule to defend yourself. When an officer tries to disarm you or violate your rights using that old officer safety excuse, you respond with this exact phrase. Officer, I understand that safety is important for both of us, but under the new Supreme Court standard in Martinez, I need you to please articulate the specific behavior or circumstances you've observed that would justify restricting my constitutional rights at this moment. Under this new standard, officers must justify their actions with facts, not feelings, and if they can't, their actions are no longer just bad policing. They are constitutional violations that can lead to dismissed charges, successful civil rights lawsuits, and even criminal prosecution of the officers themselves. These 10 rules aren't just legal tips from a gun channel. They represent the difference between your family having you home for dinner tonight or visiting you behind prison glass for the next 20 years. If this information could save even one fellow gun owner's life, freedom, or family, then sharing it isn't just helpful. It's our duty as responsible Americans. If you found value in this breakdown, hit that like button, subscribe for more content that matters, and drop a comment to let me know your thoughts. Stay safe and stay smart.